Whenever possible, you want to avoid the probate process. In Massachusetts, the probate process is a court hearing in which a judge will review a will and make a decision if it's going to be allowed, if it's going to be followed, if the wishes of the person who created that will, the testator, are going to be followed. Similarly, the probate process is a process by which the Commonwealth of Massachusetts will set forth a set of predetermined rules or statutes that will make a decision, because there's a lack of a will, as to what family members will inherit, who will get what, and who will make those decisions as to who gets what. It's of the utmost importance, at the very least, to have a well-crafted will, to have a clearly defined will that'll account for most situations that we can anticipate to ensure a smooth probate process. The probate process, in essence, is a lawsuit that's filed in which you give creditors and the entire world the notice that this person died and gives them a year to assert a claim saying that that person, the decedent, owes them money or has to give them some of the assets. All this can be easily avoided with the use of a properly crafted trust in which the assets are aligned with the trust. To align assets with a trust, we're talking about actually retitling those assets into the trust. And a properly drafted trust, which is properly funded, will avoid the probate process. Whenever possible, you want to avoid probate. And if by chance you are involved in a probate, it means a couple of things may have went wrong. To start, it may mean that either your heir or the person that passed away didn't have a will, and that's gonna thrust you into the probate process. It also means that you have a will and it has to get approved. And while probate is something that we can avoid whenever possible, if you have to go through the probate process, we want to do everything we can to ensure that it's as streamlined and predictable as possible. Well, how do we do that? We do that by having a clearly written will that will identify who makes decisions, under what circumstances those decisions are made, and that courts are used to seeing, that we're using a will that meets the statutory requirements, or the check boxes, if you will, that the clerks have to achieve and that the judges have to meet to allow the personal representative to be appointed and the will to be probated. And it's a long process. When a person's going through the process of probate, you're looking at 12 to 16 months with assets being tied up for at least a year. It can get expensive. Probate also gives family members and creditors the opportunity to contest a will and to say, the person who wrote the will at the time they wrote the will wasn't of sound mind, or they were influenced by undue coercion, or when they wrote the will, it wasn't written in a way that it truly gave the intent of the testator. It was influenced or poorly written, or their intent was to do something else, but the will says something completely. So a poorly written will can almost be worse than not having a will at all. A poorly crafted will is going to create ambiguity. And we want to stay away from ambiguity because now it's going to be subject to interpretation. How do we interpret a will? Well, you get two lawyers in a courtroom before a judge advocating or arguing for their client as to what a particular word means. I don't know about you, but I don't want what happens with my assets to be determined by one word and what it means. So by having a clearly written will that outlines exactly what's supposed to happen is going to save you time and money and heartache and aggravation. And all of that can be avoided by avoiding the probate process. One of the best tools for avoiding the probate process is the use of a trust. By having a properly funded trust, we are going to ensure that you don't have to go through probate, that your assets are protected, and that they're disseminated to the beneficiaries in a manner in which you choose. And in some instances, that matter may be not as simple as just giving it to your children or your grandchildren. You may be providing those assets to your children in a way that protects them. I often tell clients that if something were to happen to you and you didn't have a will, your assets would vest in your children when they turn 18 years old. Now, handing an 18-year-old $1 million or $500,000 or multiple of millions of dollars never has a good outcome. Certainly know if I were turning 18 and somebody handed me $1 million, I may go out and buy a Maserati or spend my money a little frivolously. And as we get older, we learn how we want to spend our money and what the right thing to do is, and use that money for good, for growth, for helping our families. Within our trusts, we create guidelines on how money should be disseminated. We use something called HEMS. HEMS stands for health, education, maintenance, and support. Oftentimes our clients want to ensure that their loved ones are given this money, but on the same time, they want to protect them against themselves. So we designate a trustee who will, under our direction, be allowed to give money to our heirs, so long as it fits within the category of health, education, maintenance, and support. Now that can be pretty broad. In fact, we have provisions within our trusts that says, do we want to interpret health, education, maintenance, and support liberally, or do we want to interpret it conservatively? And that's a conversation that we have with clients all the time. How do you want to define it? Do you want to define maintenance as the ability for the trustee to buy your heir a Maserati? Or do you want to do something maybe a little more conservative, a new car with low miles or no miles? Those are all decisions that we talk about and really find out from our clients what's important to them and what are they trying to accomplish. So estate planning is the larger umbrella of the entire process. And oftentimes I'll use the term estate planning and it creates a little confusion to people. People come to me and they'll say, I need a will. And I oftentimes will use that word by meeting the client where they are. They're used to using the term will. But we tend to call it estate planning because to put together a proper plan is much, much more than just drafting a will for a person. Estate planning involves much, much more than just drafting a will. There are 4 components to an estate plan, or at least to a properly crafted estate plan. And yes, a will is one of the first components, and a will protect your estate after you pass away. But really, for most of my clients, one of the more important components is a durable power of attorney. Now, what a durable power of attorney is a document in which you designate another person, we call that person your attorney in fact, to make decisions, and now these are decisions that are financial in nature, in the event that you cannot make them. And a durable power of attorney is a document that we call it springing, which means it springs into action upon the happening of certain events. Well, what does that mean? Let's break it down. A durable power of attorney will come into play or become effective if you're disabled. If 2 doctors say you're unable to make decisions, a durable power of attorney will become effective if you disappear or are detained for greater than 30 days. And a durable power of attorney will spring into action, as they say, upon a certification. So that's a document that we include in every one of our estate plans that says, upon signing this document, I want my power of attorney to become effective immediately. And in a lot of situations, we use this springing, durable power of attorney. In other situations, when we have older clients or people who really require the assistance of their family members, we would use a durable power of attorney that's effective upon execution, right then and there. And we create those documents in which we name the person's children, or son, or daughter, or loved one, or caregiver as the attorney in fact, the person who has the responsibility of making these decisions, and allow them the ability to make those decisions immediately. The second document that's under the umbrella of an estate plan is a healthcare proxy. The healthcare proxy, much like a durable power of attorney, is a document in which you cloak the healthcare agent. That's the person that you choose to make medical decisions on your behalf with the responsibility of making medical decisions. Those medical decisions can be as simple as, can this person get a surgery? Should they get a surgery? To as serious as, do we want to terminate life support? And that decision is made by an additional document that we include in our estate plan that's called a healthcare directive or a living will. And the living will works in conjunction with the healthcare proxy to make decisions or to cloak your caregiver with the ability to terminate life support under the circumstances that you designate. And we spend some time talking about that for clients that need that part. And for others, we have language that's pretty encompassing and that is used often in the Commonwealth of Massachusetts and is generally accepted language. So if you find that part of the process to be most difficult, we can kind of come to the decision but gloss over a lot of the details of it and still meet your wishes. The next document that we put together is a series of documents, and they're designed to help make the estate plan more comprehensive. And those documents include a personal property memorandum. And this is something that our older clients really tend to like. Within that document, we give it to you as a blank document, and you can make decisions that I give my Rolex watch to my son, or my brooch, or my grandmother's brooch rather, to my daughter, or my engagement ring to my niece. And we provide you with documents that at your leisure will allow you to make those choices at a time when you want to. Another document that we have that I recently learned about and realized how important is a memorial services memorandum. About 2 years ago, my father passed away, and I was in a funeral home with my wife, and I spent 3 hours being asked questions. And I didn't know these questions. I didn't know what high school my father went to. I didn't know what military awards he won. I didn't know what organizations he was a member of. It just wasn't something that we talked about. And that's often the case, that people aren't talking about those things. And I proceeded to go through this process and didn't know the answers to the questions, and we kind of had to call people and ask the questions. It was really not what I wanted to be doing for a couple hours in a funeral home. At that moment, it just wasn't something I wanted to think about. And I said, how can I solve this problem? And as a result, we later on went through and thought about the questions we were asked, and we created a series of questions that are included in our estate plan that our clients at their leisure, when they're ready and if they're ready, can answer and save their heirs the uncomfort that I went through on that day when that was the last thing that I wanted to be doing. So what's important to remember is that estate planning, particularly for my firm, is an evolving process. The estate plan that I had and was giving to clients 10 years ago is very different than the estate plan that I'm giving now and providing to our clients 10 years later. We all grow as experts and as attorneys. We call it the practice of law for a reason. And as we do more of them, we get better at them. We add things. As scenarios occur, we continue to evolve our estate plans. I tell all of my clients that estate planning is a process and not an event. And that's really something that's important to remember. And we encourage clients to meet with us either yearly, sometimes twice a year. For people who have trust-based plans, we want them to meet with us even quarterly at times. But the driving factor is meet with your attorney upon a major life event. A major life event might be coming into money, having a family member die, having children turn 18, and having events, getting married. Call us today.